All right. Welcome, everyone, to the third in our Know Your Nonprofit Rights webinar series. This is Kagan Ann, Director of the Charity and Security Network, a nonprofit based in Washington, D.C. that brings together nonprofits of all kinds to deal with the issues and complications that security laws present for our operations. Today, we focus on how nonprofits can handle government investigations. Enforcement can be civil or criminal by local, state, or federal authorities, and it can have a negative effect on nonprofits, whether they are the target of the investigation or not. Our expert, Timothy O'Toole of the law firm Miller & Chevalier, will explain how to prevent, prepare, or respond when government comes knocking on your door. He will include information on dealing with Treasury's Office of Foreign Assets Control as they enforce counterterrorism sanctions which can impact international programs. In the current political climate, nonprofits need to know their rights, how to be prepared in case of a visit from law enforcement, and how to respond if that happens. After our speaker's presentation, I will ask a few questions I've been saving for today, and then you will have an opportunity to ask questions and make comments as well. Now it is my pleasure to introduce Timothy O'Toole, a member of Miller & Chevalier. He counsels and defends clients, including nonprofit organizations, in white-collar criminal matters, conducts internal corporate investigations, and represents potential witnesses and targets of government investigations. Although Mr. O'Toole has substantial experience in all areas of white-collar practice, his main focus is on economic sanctions and export control. So here, Timothy, I'll hand it over to you. Thank you.
Thank you very much, Kay, and good afternoon, everyone out there. I think it's now safely into the afternoon, and thank you for having me. As Kay mentioned, I've been defending people and companies my whole life, and mostly in the last decade or so, mostly focused on economic sanctions and export controls, which has plenty of implications in the nonprofit context. But I also want to start by just kind of going over some scenarios that may be applicable to your company or to you as an employee of a nonprofit company. So let's start with kind of how these government investigations kind of get started. I've got a list in this slide of various scenarios that could signal that there is an investigation. You'll see there are some subpoenas. And there are different types of subpoenas, and we can talk about that briefly before the question and answer session. There's what I've got in quotes is outreach from U.S. regulators, and I know in the OFAC area and actually in the export controls area, so the Commerce Department, the government has a number of what they call outreach programs, and which kind of on their face look like they might be just designed to build up friendly relationships, and there is some truth to that, but I also would suggest that there are also many situations in which this outreach is happening because the government is essentially trying to create evidence for use in either a civil or a criminal case. Other times when you might know that investigation is starting, you might discover it yourself. You might be conducting some sort of internal audit and realize that your organization has problems. I have on the slide something called the SDNs, and that the organization has conducted transactions with SDNs. That is kind of a term of art in the OFAC world. An SDN is a specially designated national, and that is someone that OFAC has decided that people in the U.S. can't do business with, and so they put them on an international blacklist and call them specially designated nationals, and U.S. companies, nonprofits, U.S. people, pretty much anyone with any connection to the U.S. can get into a whole lot of trouble for doing business with SDNs. And so that might be another way that you find out that you've got some issues. You might find out from an arrest of one of your executives. I think that's that is hopefully a scenario that never happens to anyone on the phone, but in my experience, that has happened. I've not had it happen in a nonprofit context, but I've certainly seen it happen in the for-profit world. And because, as I'll discuss later, some of these rules and some of these investigative techniques have certainly spread over into the nonprofit world. It is something that you should keep in your back of the mind that could God forbid, happen to somebody in your company. A whistle, you know, these issues come to light through whistleblowers. These issues come to light when the police show up at your organization with a search warrant, and there's other ways they can come to light as well. I mean, you know, you file various forms with the government, and sometimes people, certainly at OFAC, get curious by questions that you've answered on the form. So, for example, if you have a nonprofit that does humanitarian work overseas and it looks from the form that you might have done work in an area that the government is interested in, and nowadays that usually starts with Syria, Iran, Cuba, you know, North Korea, those sorts of areas, you might start getting questions from OFAC, and at that point, you have to decide, what are we going to do? And so what I've got on the next slide are you've got some possible responses. You can play defense, and what I mean by that is you can kind of just sit back and wait to see what happens. And there's some situations where that is exactly the right approach. There are situations where you'll get a subpoena, and it's clear that you are just a witness and that your role is very innocuous in some sort of ongoing proceeding, either criminal or civil. You're solely being asked for things that don't give you any pause that you might be in trouble. And so at that point, it's not clear that you're going to need to go and try and figure out exactly what it is that the government is getting into, because it seems pretty safe. You also, if what you're approached with is some sort of outreach, you know, you may play defense by just referring the outreach to counsel. And what I mean by that is, particularly the Commerce Department, although OFAC does this some too, they will send people from their agency to your office, and they will say, we're just here to kind of let you know what OFAC does. We're just here to let you know kind of what the Commerce Department does with respect to export issues, or whatever government agency shows up. Do you mind if we look around a little bit and talk to your people and that sort of thing? And they'll chat about, you know, various issues of interest to OFAC or to Commerce Department or to whatever agency you're dealing with. And you know, I generally tell clients that that is just not something that they want to get involved with, at least at the start. And there are instances where that, you know, that might be okay, but you usually at that point want to at least try and have counsel that you can talk to figure out exactly how you're going to deal with those outreach issues. You know, whistleblower complaints, you can decide this is not a big deal. We're just going to address the complaint, but we're not going to do anything more. Normally, though, if the issue looks like it might be big at all, I find that it's best to try and get ahead of the issue and try and figure out exactly why you got that subpoena, or exactly why the outreach is happening, or address the whistleblower complaint. I mean, there are other issues that certainly, you know, you're going to know that you're going to need to really either get ahead of the issue or at least figure out what's going on. If the police show up at your organization with a search warrant, I mean, at that point, I think that you know you got to get a handle on this if you're completely surprised by it. And the other things that I've got on here, you know, where the response is more voluntary, you do want to have internal policies and procedures. You want to think about having those procedures for what do you do when the government shows up with a search warrant? What do you do when somebody shows up for outreach? What do you do when a whistleblower complaint comes in the door? What do you do to deal with these SDN issues that I talked about before? And then, you know, you may want to think about, if the issue is the right one, about conducting some sort of investigation. And when I say investigation, those can range from very small sorts of just review of the documents. You know, it might even be a handful of documents or talking to a couple of people. And they can range all the way to months or year-long investigations if the issue is big enough and the problem is significant enough and there's enough records and enough people that are involved. So I'm using these terms kind of generally, but they can mean, you know, an investigation can mean hours and it can mean years, and it just all depends on the issue. So why would you want to investigate if this sort of thing happens? Well, you do want to get to the bottom of the issue and figure out what it is. If it's something that can get you in trouble, you want to prevent it from happening again. And I think you want to do it quickly usually, because, you know, by the time the government shows up at your organization with a search warrant, there usually have been a number of warning signs along the way, and you may well have, by kind of paying attention to those warning signs and dealing with the issue, you may have been able to prevent the problem before it got to a search warrant. Also, at least in the OFAC space, one of the things that's that is very important, and I've done this with nonprofits, I've done this with for-profits, and I've done this with individuals as well, is that they have a voluntary disclosure policy that if you disclose an issue to OFAC when you find it and before OFAC finds out about it, the sort of treatment that you get with respect to that issue can be much, much, much more lenient than it would have been if OFAC had discovered the issue on its own. And you can only, sometimes you'll decide you don't want to disclose anyway, but you can only make that decision if you know what the issue is and kind of what the options are. If you wait until OFAC discovers it, obviously that option is gone. Another reason to investigate is to make sure that if you have a problem, you can, figure out what the problem is and deal with it, maybe before anyone ever finds out. And so that's another reason to really investigate early and try and figure out what the issues are. And the other reason to investigate is because if you do this right, your entire investigation can become cloaked under the attorney-client privilege, which means that, if you find out things that you don't want anybody to know, that information will not be susceptible to a subpoena. Nobody will be able to get a hold of it. Not the facts themselves, but the fact of the investigation and kind of what it is that you did to deal with the issue will be known to the company and to nobody else if that's what the company wants to see happen. The company can decide that it wants to publicize the investigation as well, but I think that if you investigate and you do it early, that you create more options for the company to deal with particular issues. And the other reason that you want to kind of get on top of these issues right away when you see the first sign of them is because the faster you do it, the more that people will remember, the more documents will exist, and the longer you wait, that sort of thing fades away, and you may never really figure out what happened. And you're also sometimes, if the regulators find out about it, you're left to kind of fading memories that can get things wrong, and sometimes wrong in ways that don't help. You're left with documents that may have really exonerated the company, but they're not there anymore. And so I mean, it really is to protect yourself, but also to make sure that whatever facts are found are actually the true facts and not the fake ones. So why am I talking about OFAC? Why are people and companies worried about OFAC? Well, I put up a chart whenever I talk about OFAC to talk about just these are the top 10 civil fines, and most of them are within the last 5 years. You'll see that they're all against banks, but the banks were involved in particular transactions, some of which could have been transactions involving nonprofits. Certainly, there were lots of transactions that these banks processed, mostly through Iran, Syria, Sudan, and Cuba, sometimes North Korea. But those transactions were processed by these banks in violation of U.S. law, and you'll see the Paribas fine was $963 million, and that was just OFAC's part of the puzzle. The total fine for BNP Paribas was around $9 billion, $9 billion with a B. So it can be a big deal if you get into trouble, and that's just separate and apart from the fact that people can go to jail for violating these laws. Now, how does this apply to the nonprofit world? Well, I mean, I have this slide that says OFAC knows you exist. And what that means is that OFAC actually has a web page that's devoted to charitable organizations. And what they mean by, and what they're usually interested in is that OFAC manages the embargoes that the United States deals with around the world. So the Cuba embargo, when you're talking about the Iran embargo, when we're talking about the embargo on Sudan or Syria or North Korea, that's usually run by the Office of Foreign Assets Control. It's in the U.S. Treasury, but OFAC deals with those, and OFAC is the one that polices those embargoes for the most part. And what they normally deal with nonprofits is that the embargoes prohibit the provision of services in any of these countries. And so they can have exceptions to the embargo, but if you provide humanitarian services or goods in Syria, for example, and you're doing purely humanitarian and wonderful work, you can run afoul of the embargo. Same thing for all the other embargoed countries. And that's the main way that nonprofits get into trouble. The other way that nonprofits can get into trouble is that, another service that you could provide in these countries is insurance. And many insurance companies are organized as nonprofits. So insurance companies can also get in trouble with OFAC for providing insurance services in embargoed countries. And I think that's the normal way, or the main way that nonprofits get into trouble with OFAC. So these, I think, are probably this slide kind of lists the main risks and gives you kind of at least a current view into the embargo countries. Because the embargoes are usually based on foreign policy issues and those can change from day to day, this list changes, although Iran has been on it for a long time. All of these countries are long-time members of the embargoed countries list. Sudan may soon be off it. One of the last things that the Obama administration did was that it suspended the Sudanese embargo through July 12th, and if Sudan continued its progress, it was supposed to lift the embargo on July 12th. That's supposed to happen automatically. There's been some noise that the current administration may change that, but in a month, the Sudanese embargo may go away, so we'll have to watch that. But for now, those are the list of the countries that are embargoed by the U.S. And I put this piece of OFAC guidance regarding Syria up there, not because I necessarily think any of you all are doing business in Syria or that may be your primary area of interest, but I do think it's helpful in just kind of understanding how broad these OFAC restrictions are, how OFAC does look at the fact that humanitarian organizations can run afoul of its sanctions regime, and also it has things in it that if you're doing this sort of work, you should know about. There are things called general licenses, which is OFAC says this is prohibited by the Syrian embargo, but we license without having to make an application any of the following activities. And as long as you are doing those activities and only those activities, then you are subject to OFAC's general license. You don't get a piece of paper that shows a license. That's what's called a specific license in OFAC speak. But that's often how the humanitarian aid is kind of allowed through OFAC rules, but there's very strict requirements that you'll have to meet if you're trying to provide humanitarian aid in any of these areas. But I thought that answer was one that, if this is areas of interest to you, that's something that you can kind of look at that's concrete, that OFAC has told you what you can and can't do. I've got another slide that talks about a humanitarian company or a humanitarian nonprofit that got a $780,000 fine a couple of years ago for they were providing assistance in Iraq when there were sanctions on Iraq, and they did it in a way that was designed to disguise the fact that they were providing that sort of assistance. And so, the management kind of helped them. I think OFAC would say that they laundered the funds through Jordan in order to get them to Iraq, and so they got in big trouble with OFAC. My only point here is that this is something, if you think that OFAC would never pay attention to your organization, there are indications to the contrary. And then, these are some of the normal slides that I give when I give my OFAC talk, but I do want to just kind of brush through them very quickly. I won't focus on any of these enforcement actions, but OFAC, you shouldn't feel like if you're a nonprofit that's organized somewhere else besides the U.S. that you're safe, because OFAC has very broad rules that it uses to enforce the U.S. sanctions regime, and so sometimes foreign companies and foreign people can be in the crosshairs of OFAC. And these are just a few of the many enforcement actions against foreign companies that OFAC has taken to enforce parts of the embargo. SDN screening, I touched on that a little bit earlier. That is you can't do business with certain entities and individuals. Well, how do you find out which ones you can and can't do? There are software screening programs that are pretty good in catching SDNs, and so a lot of companies generally what they do, and if they are going to do a transaction with somebody, they run them through their SDN screening. Certainly a long-time customer. Certainly if you're doing business overseas, you ought to be thinking about doing things like that. This chart here is just a list of companies that have gotten in trouble because they didn't do their SDN screening or they didn't do it properly. And you'll see PayPal was on there. They were doing a lot of business with SDNs for a while. I think they probably got their screening system improved by now, but it happens to everyone, or at least it can happen to everyone. So something to think about if you're doing business in high-risk areas. Facilitation cases. Facilitation is another thing that you should know about in this area, and I'll touch on it real briefly. So one of the things that you can't do, even if the embargo applies only to U.S. persons, and some of these only apply domestically, and for example, now it's legal for most non-U.S. companies and non-U.S. persons to do business in Iran. The U.S. doesn't have anything to say about that. But if a U.S. person gets involved and participates in any way in the transaction, OFAC considers that to be facilitation, and that can create a lot of problems for everyone in the transaction. So basically, facilitation is when a U.S. person helps a transaction that is legal, but it would be illegal if they participated in it. And so it's a very muddy concept, and OFAC has really been starting to increase enforcement in this area. But I think it's something that, you know, you can get caught up even if it looks like the transaction is otherwise completely legal. And so it's another reason that you've got to be careful if you're doing any activities in prohibited jurisdictions. And then, you know, how do we finish the investigation? So say we've investigated, we found some of these issues. You know, you want to figure out put your handle on the facts. You want to get a handle on documenting the facts. And then you want to decide kind of how you want to disclose it or how you want to fix the problem. I think the beauty of any investigation, big or small, is that it really does let you deal with the problem and move on, as opposed to having it fester out there and the police show up at your door at some point. So that's my pitch, and that's what I look like in a tie as opposed to what I'm wearing today. But so you can imagine that if you think that I look a little too casual, that I am wearing that tie for the purposes of this presentation. I hope that was helpful, and I'll be happy to respond to questions at this point.
Thank you so much, Timothy. I'm going to take the moderator's prerogative to ask the first few questions, and then we'll go to questions from participants. First, on the criminal side, if the investigation is by the FBI or Department of Justice, and they come knock on your door with a search warrant, or say they want to question your staff or board members, what do you tell the receptionist to say? What do you tell your staff and your leadership to do?
Well, I mean, there's a lot of situations they could come knocking, but let's start with the one where they come with a search warrant. When they have a search warrant, you want to get a copy of the search warrant. You want your receptionist to then kind of alert probably the highest level management that you have. You can't really do much to stop them. They've got judicial permission to go through whatever's on the search warrant and usually to seize it, to take it back with them to the FBI. So there's no way to stop it. But what you can do is kind of, in some ways, control it by getting a copy of the search warrant, because they are restricted in what they search for by the terms of that warrant. You also want to try and make sure that somebody from your company, so, you know, I think if it's the receptionist, they're going to want to talk to probably the leader, the highest level person at the company that's there, just to have them interface with the FBI, because they'll probably be the one that, you know, whoever's in charge will be the one best able to make decisions about this. But I think you also want to have a procedure where you have somebody who's assigned to kind of walk around with the FBI and document what it is that they're taking from you, because, you know, there can become questions later on about what they did and didn't take and that sort of thing, particularly if there's litigation about whether they went beyond the scope of the search warrant. So you want to document. And then, you know, in terms of your interactions with the FBI, it is never a problem to say, for anyone in the company to say, we'd be happy if it's more voluntary, and you know, if they're talking to you, and even when they have a search warrant, you still don't have to talk to them, to just say, I'd love to talk to you, but before I do, I'd love to talk to my lawyer. And even if you don't have a lawyer at that point, it often, you know, and sometimes they'll try and talk you out of it. They shouldn't, but they will. But I think, you know, that is something to remember when you're dealing with law enforcement officers, is that I've had many clients throughout my years as a public defender, all the way up through my years as an OFAC lawyer. Many clients think they can talk their way out of trouble, and it almost never works. And when it does work, it works just as well later as it does immediately. If the police are there with a search warrant, nobody's talking their way out of trouble, and you just have to remember that. And so, you know, you want, obviously, if you do decide to, and I think, you know, company employees should be told, if they do decide to talk to police, and normally, you know, you can figure out a policy as to when they're allowed to talk to police on behalf of the company. But if they do decide to talk to police, tell the truth. I mean, that's the other thing that's really important, because lots of times people who think they can talk their way out of trouble, you know, exaggerate or do things that they think they're little white lies, and that can get you into much more trouble than whatever the underlying conduct was. So those are basically my rules that I give to people when they want to know what to do when the police come knocking.
So, I have another question, which is, what are the most common mistakes you see organizations make when there's a government investigation, and how can those be avoided?
So I think there's a couple. I mean, I think the main mistake that I see made is kind of letting the problem fester and get bigger. So, for example, you know, you can have a small issue, and it's an issue that's pretty easily dealt with. You could change a few policies. You could figure out the issue in a couple of hours, and you could really fix it. And instead of fixing it, they just kind of become paralyzed and let the problem, you know, assume that the problem will go away, or assume that it's not a problem at all. And, you know, at some point, they've missed all these warning signs. There are, you know, potential requests for information, outreach visits. There are, you know, calls from the FBI. There are, you know, all sorts of other things along the way that if you were paying attention, you'd know maybe we've got a problem, maybe we should figure out what it is, maybe we should deal with it, and they don't. And by the time they get to the, you know, you get to the knock on the door by the police with a search warrant, you've missed your opportunity to really deal with the problem, and you're going to have to you're in big trouble at that point, and it's going to be out of your hands. The remediation may not be possible because it's too late, or if you can remediate, you're going to also have to pay a significant fine, or people might go to jail when they otherwise wouldn't have. So I think not dealing with problems when they're manageable is probably the biggest mistake that I see both nonprofits and individuals make. And usually the solution is just wouldn't be that expensive, or wouldn't be that you know, time consuming, but by the time they deal with the problem, it becomes very expensive and very time consuming.
It's very helpful to know, and probably a very easy mistake to make.
Yes.
For our participants who would like to ask questions, there is a question pane on your screen on the right-hand side, and a little arrow. If you click on that arrow, it'll open up the pane. You can type in your question. If you would like to make a comment or ask the question yourself, use that pane to let us know, and we can unmute you. In the meantime, we do have a question from a participant who says, my question has to do with taking donations for your nonprofit from overseas to conduct 100% legal nonprofit activity in the USA. What would you recommend for such an American nonprofit receiving some donations, some large in quantity from overseas, to help it conduct normal 501c3 work in the U.S.?
So that's a great question, and let me start by saying, I mean, obviously, all of the answers to questions like that would involve kind of full knowledge of the facts, and so I'll give you some friendly advice, but to get real legal advice, I'd probably need to know a lot more, and I wouldn't be able to do it on a call. I'd have to address all the kind of crazy bureaucratic issues that you have to address when you do that for a firm. But kind of to get back to your question, if you're taking money from overseas and using it in the United States to provide humanitarian work, the biggest risk is making sure you know kind of who the donors are, and then making sure that it's okay to accept money from those donors. Some nonprofit organizations have gotten into trouble because the DOJ or the FBI have decided that the donors to that nonprofit organization were either on SDN lists or were on foreign terrorist organization lists, and so the U.S. nonprofit got in trouble for essentially accepting money from either what the government has described as terrorist organizations or SDNs or somebody on a U.S. blacklist. And so I think the biggest thing to do immediately is kind of figure out who's giving you this money and figure out whether it's okay to deal with them. And when I say figure out who's giving you this money, it's not just a matter of who the money is coming from on the banking wires. So that's one important thing, but you really do need to get to the bottom of where is this money coming from, especially if it's a big amount of money. But I mean, any amount of money can get you in trouble. But so for example, if you've got a lot of money coming to you from a restricted part of the world where there are a lot of SDNs, you know, you got to make sure that not only is the donor okay, but that the donor, if it's a company, isn't owned more than 50% by somebody who the United States has put on to an international blacklist. So, you know, accepting money does create, you know, the sorts of OFAC risks that I was describing, and I know that at least one charitable organization in Chicago got into a big amount of trouble because the money was coming from places that the government didn't think they should have the money come from.
So I have another question. So while I wait for participants to type in some more questions, the answer you just gave, it also raises the level or the question of the level of donation or the level of due diligence a nonprofit conducts. In what OFAC has said back in the Somalia famine in 2011, and since they've told nonprofits not to be too worried about enforcement if you're a legitimate organization, because it's not an enforcement priority to go after legitimate charitable organizations. How much safety does that provide, that kind of statement from government, and how do you see nonprofits navigating kind of that tension between the strict liability, almost standard of barring all transactions of SDNs and the kind of the practical approach that government seems to imply by saying prosecuting legitimate nonprofits is not a priority?
Right, and I think you should take a little comfort from that statement, and it's consistent with the OFAC policy and with all of the U.S. government regulators' policy in terms of how it is that you're supposed to go about dealing with these risks. What they say is you're supposed to take a reasonable approach to dealing with risks that is tailored toward whatever your nonprofit is doing. And so if you are a nonprofit in the U.S. that is providing services largely or entirely in the U.S. and not accepting, you know, money from kind of the most obvious kind of hotspots in the world that might get you in trouble, certainly not large amounts of money from there, your risk is probably pretty manageable. I still think, you know, it may make sense to put all of your donations through SDN screening, but OFAC has been very clear that SDN screening is not required, that you know, there are some organizations that don't face the sort of risk where they need to do SDN screenings, and so and it can be somewhat expensive. It's usually not terribly expensive, and you know, one form of SDN screening, OFAC has a website and it has an SDN list, and you can search that list manually. And I think for most nonprofits, they don't necessarily need to go buy a commercially available screening tool. They might be able to get by with doing that because they really would be only screening the money coming in or the customers that they deal with that are present obvious risk. But I think, what the comfort you should take from that statement is that it's not just limited to the nonprofit community, in the sense that OFAC has said if you're a legitimate business and you're essentially paying reasonable attention to risks, you're not going to be an enforcement priority. The problem is, and traditionally they haven't gone after a ton of nonprofits, although they have said in the last couple of years that they were going to consider going after the insurance industry, which often is organized into nonprofits. But that said, I think take some comfort from the statement, but you have to understand that when OFAC says if you're legitimate and if you're doing legitimate business, what they mean is if you're not doing business with SDNs and you're not doing business with foreign terrorist organizations, and unless you're actually trying to make sure that you're screening properly, sometimes you can do that sort of business and not even know
it. Would your answer be any different for an organization providing assistance to beneficiaries in famine-threatened areas, say in Somalia or Yemen, or places where there are non-state armed groups that are on the list?
Yeah, I mean, yes is the short answer. I mean, that's when I talk about a risk-based approach, I think that probably most people on the call are not in high-risk areas. But if you have an organization that is doing humanitarian work overseas, most of the places that you would be doing humanitarian work, almost by definition, are in big trouble. And the places that are in big trouble are the ones like Yemen or Somalia, or the sanctioned jurisdictions, where either there's a lot of SDNs, because the OFAC doesn't just make SDNs in embargoed countries, it also makes SDNs in places where there's just a lot of trouble. And so there are a lot of SDNs in Yemen. There are not as many, but there's still a decent number of SDNs in Somalia. There are a lot of SDNs in Russia and in the kind of the former Soviet countries. And so you do have to be careful if you're doing work overseas, and I would think in the normal places you'd be doing humanitarian work, you have to be extra careful.
Okay. Do we have any more questions from our participants? I don't see any. I think we may have, in the thoroughness of your slideshow and your answers, provided most of the answers to questions people have. I guess one more question. I'm sorry, we have one more?
Yes. Can you see it, or?
No, I didn't. This is Andrea. Can you read it?
Sure. Beyond OFAC SDN, EO 13224, and State Department lists, what are other lists or issues we need to be aware of as a U.S.-based international NGO? Do we need to monitor UN and EU lists?
Well, I mean, I think, the short answer is you might. I mean, it depends on how you're organized and who works for your organization. So, for example, the EU lists, anybody who's an EU citizen is going to have to comply with those lists. And so if you've got people working for your organization, they could get in trouble if they run afoul of an EU list. I think in terms of UN lists, it's the same. It certainly can't hurt. I mean, if you're doing work in a place that has a lot of these listed parties, then I think the more lists you check, the safer you are. That's one of the big benefits of a commercial screening software, is it usually checks all these lists. There are other U.S. lists as well. I mean, the OFAC SDN list is the main one, but there's also the Commerce Department has something that's called the entity list, or the denied parties list, and the requirements that apply to each of those lists vary from list to list. I mean, they're different programs, but I think that if you are providing humanitarian assistance and shipping goods into these areas, you might run afoul of the denied party list, and certainly the entity list might come into play, because the entity list in the Commerce Department is one that basically the Commerce has listed a bunch of companies that you can't send any U.S. origin goods to without a license, and for some of them they won't give you a license to send it to them. And so It's not as bad as the SDN list, with whom all dealings are restricted, but there are other lists out there in the U.S. and abroad that you ought to be thinking about if you're doing work in high-risk areas and you have, international group of employees. You may be governed in some ways, or some of your people may be governed by all of these lists.
Okay, Andrea, do you see any more questions?
Yeah, there's a third question that came in. It says, for NP, nonprofit legal services organization, provision of and payment for legal services, what are the limits of the OFAC general license, and does required reporting violate confidentiality?
Can you repeat the question? I didn't hear the first part of it.
I'm sorry. For nonprofit legal services organization, provision of and payment for legal services, what are the limits of the OFAC general license, and does required reporting violate confidentiality?
Let me see if I understand the question. So I think that was I don't have all of the general licenses memorized, but I'm assuming that was probably the Syrian one that was in one of my earlier slides. And so normally, I mean, the problem with kind of opining on the limits of a general license is that every single different program has a different general license, and some of them don't have general licenses at all. And so I think, normally the limits on the humanitarian general licenses are that you actually have to be providing humanitarian services in the region, and there are certain restrictions on what sorts of goods that you can import and who you can deal with. Those are normally the limits. And then the other question is about the reporting requirement, and often in OFAC programs, even if you have a license, there are requirements that you report to OFAC. In terms of the privacy interest that you might violate, I'd have to take a look at the specific reporting requirement that you're talking about. Sometimes, first of all, the reports aren't necessarily public or FOIA-able, but to the extent that they are, I could see a scenario where OFAC might want information that could be protected by privacy interests. But I think I'd need to know more to know exactly kind of how those interests are at stake. But I think that it's a great question, because it highlights some of the things that can happen with OFAC in terms of OFAC is very focused on U.S. interests. OFAC is very focused on limiting and restricting all sorts of goods and services in certainly in embargoed areas, and sometimes that counteracts with other important values like privacy and also like providing humanitarian assistance. I mean, sometimes the rules are so strict that even though the humanitarian assistance is technically allowed, it doesn't happen. And I think that's something that, because of the way OFAC operates, is not maybe given as much priority as it should be.
I will add that there is a regulation that Treasury put out early in the Obama administration that authorizes provision of legal services to
Yes.
SDNs in some circumstances, particularly when it's on a pro bono basis. And there's a summary of that on our website, and we'll make sure to include the link to that and other information coming out. Do we have any more questions? Not hearing any. I'd like to offer Timothy a chance to provide any closing thoughts or tips or things that we should be keeping in mind as we go about trying to do our work, especially international work in this current political climate.
Well, sure, and thanks. I mean, I think, my first thing that I would say is, thank you to everyone on this phone for doing the great work that you do. I think that, nonprofits are one of the most important parts of what makes America great and has given America a wonderful reputation around the world, at least historically. And so I think that, I hope I didn't scare you too much, because I think that there are ways to keep doing your work, even internationally, even in kind of the hottest of hot zones, which is where it's needed the most. And I think that, one of the things that Kay just said is important. Legal services are authorized not only just with respect to the SDN programs, but are generally, in the last 8 years, the OFAC expanded the number of situations and the availability of providing legal services even in the embargoed areas. And so I do think that, you know, if you have questions about this, it is important to try and figure out what you can do and what you can't do so that you stay on the right side of these issues. I think that for the most part, historically, the U.S. regulators have been pretty forgiving of agencies that are doing, you know, good work abroad. And I think that, you know, it's important to stay on the right side of the line, but it's also important not to have the important work that you all do be deterred by a bunch of government regulation that's very hard to pierce through. So thanks for being here today. I really appreciate it, and I hope this was helpful.
This is very helpful. Thank you for taking the time to share this expertise with us. I'd like to also thank the participants for joining us today, and to let you know that this webinar will be posted on our website shortly. You can see it there or click on events. You'll also see links to recordings of prior webinars and watch for announcements of future webinars that we will be holding throughout the year on this Know Your Nonprofit Rights topic. We also encourage you to join the Charity and Security Network if you have not already done so. And there is a join button and a donate button also on our website. So again, thank you very much. As always, contact us when you have questions or need more information, and we look forward to staying in touch. And again, Mr. O'Toole, thank you very much.
Thanks for having me.